the first to know. Nsem-Pii TV.
After the judicial declaration by Justice Japan, our High Court against the 4 NDC parliamentary candidates and a lawyer Eduji Tamaklo against the Mandamus application of the new patriotic party lawyer Gary Nimakono. Saying electoral commission for etimi organizing elections at the declaration of results na obidi akwakopiem court say electoral commission omo constitutional duties omo entimi anyewie inti the high court emma ho kwan na omo ntimi enwie omo dwom na sasam na lawyer Gary Nimakon edekopiem high court no wanfa nkwankopie ho trasa the entire assembly enya weight a carry weight a video evidence or the attach in the case. One of the video evidence and the Bremo, especially in the declaration of NDC parliamentary candidate as winner Ebi Bright Ewotema Central constituency. I know that video as one of the video evidences tendered in court by lawyer Gary Nimakon against the NDC parliamentary candidates on the case. What are some of the issues? Lawyer Gary Nimakon say electoral commission yamaho kwan amomantimi wiomejuma. NDC parliamentary candidates say San Crawford omunfa omo case ekopie in the police station Emma court inquiry and we evidence na and fa judgment in by intimi mfa electoral commission for omasem na trasa share this particular video ye ba reporter a PMO directly from court lawyer Gary Nimakon account for about this particular video no na ye de sanchichi mono aide apa nyinko de question.
He started it.
Rejected ballot 141, but total ballot vote 37,308. By this result, I hereby declare Madam Ebi Bright.
Where one of the video evidences tendered in court by lawyer Gary Nimakon. Na ansa na oba kasano lawyers of the electoral commission so no wo omo the statement be tudra yemfa eno quickly embra ansa na call lawyer Gary Nimakon statement. Justice Amenuvo, counsel for the electoral commission in the Mandamus application hearing, has prayed the high court to make appropriate orders that will enable the electoral commission to complete the coalition process in the various coalition centers in dispute. Apart from declaration by Justice Japan, Justice Amenuvo say court no under the making appropriate orders beboa ama commission for no oma complete omejuma in the various disputed coalition centers across the country, especially in the greater Accra region. Or say if this court does not make appropriate orders for the EC to go and finish the work in the presence of the very limited number of persons outlined in the constitutional instrument CI 127, a dangerous precedent for our democracy will be set, whereby all manner of thugs, hoodlums, will evade constituency coalition centers and even without the appropriate forms prescribed in the CI for the election, raise the hand of somebody holding the A4 sheet and saying that it is done, he said. Into such statement made by lawyers of the Electoral Commission, said, Nipa no okra sheet Oma Ebi Bright then Sasso Ewotema Central not on your Electoral Commission for official or no this declaration a tuga. It's about saying Nasa declaration a official declaration by the Electoral Commission. Elias, lawyers of the New Patriotic Party, Hana, substance of the matter, have firmed up their argument that the collation of the results in the Tema Central constituency could not be completed due to alleged intimidation, with a claim that the person who declared the National Democratic Congress Ebi was not the returning officer of the EC. Inti nipa okra page sheet A4 paper, ebobo numbers, ebobo rejected ballot, ebobo numbers e can say Ebi Bright na winner, omudi ewuse, no any returning officer of the Electoral Commission. The returning officer of the Electoral Commission during that said fake declaration was nowhere to be found. Inti eba saying now to make us easy for omobio majuma, especially in the Tema Central constituency. Or see moving the Mandamus application at the general jurisdiction of the High Court in Accra on Wednesday, January 1st, 2025. That is Gary Nimakumafo pointed the court to the video which was played in open court. And this video was played in open court. He alleged that the person who was seen holding an A4 sheet in the video on the said day is said to be a purported Mr. John Nunu, and not EC's returning officer for that particular location, Mr. Kwesi Brobe. Into EC returning officer na say Mr. Kwesi Brobe, and a certain Mr. John Nunu at the A4 sheet original at the declaration to a cast a rejected ballot of these thousands of numbers, a cast a Ebi Bright in the winning election. A banner saying no, it's me official declaration of the Electoral Commission. That is a lawyer Gary Nimakumafo argument, Judge Justice Japan and then a dream. As a result, he is asking the court to compel the EC to complete the coalition process and declare who won the election for that constituency. Until lawyer Edujita Makulu Ayeka said, for election petition, but Opacha said, so fraudulent fake declaration by a certain Mr. John Nunu as a standing as an official declaration. Now MPP for MBA file election petition, but MPP say this is not an official declaration of the Electoral Commission. It's a ban saying it's me file electoral petition. You file a Mandamus application to compel the EC to officially collate its result and officially declare NIPA a winning election in especially Tema Central constituency regarding this particular video evidence of fake declaration appeal. Now, meanwhile, in the video that was played in open court to support MPP's argument, the Deputy National Communications Officer of the National Democratic Congress, Malik Basintele, was heard saying, our issue is not with the police, our issue is with the EC officer. We'll bring him out to declare Ebi Bright. Whether he likes it or not, he will declare the results here, and if MPP does not like it, they can go to court. Until Deputy National Communications Officer Malik Basintele in the video evidence, like I said, on any EC, on the police for any problem. Now, Electoral Commission returning officer Pew, so Pew obe declare ama Ebi Bright, or cost rubber former obe declare ama Ebi Bright, say MPP ba omuko PM ewo court, no omunye de omu argue omu case. We and a lawyer Gary Nimakumafo Sukasi. If the position canvassed in the affidavit in opposition of the interested parties is made to stand, it will be a very dangerous recipe in this country, because all it will mean is that without the full complement of votes from all polling stations, anybody can at all mass up at the coalition center to purport to make a declaration, which duty rests with unauthorized and determined officers of the EC to be done in a prescribed manner according to law. Say courts no I support Edujita Makulu. I partly say that Chibin will be able to sorry no the A4 sheet paper. I go as I can numbers abubu. I'm being so say or no Odin Kunim. Sadie and yes sir any edit on mine and yes sir any edit on mine and yes sir any edit send the members of parliament into parliament. Now coalition without incorporating the entire polling vote can never be called coalition in the eyes of the law. But what it seeks to do is that persons who have gone to cast their ballot are being disenfranchised. It's about say Mr. Joshua Nunu in some kind wabɔ nkurɔfoɔ bi a wɔto wɔn aba in certain police stations ato egu ɛna wa declare ama Ebi Bright as the winner of Tema Central. Wei any video evidence and promise say yɛde bɛba lawyer Gary Nimako the supporting the argument in court ama that declaration I am very strong for the 4 new patriotic party parliamentary candidates in the various constituencies. Yennemwa TT say additional information about regarding the other constituencies you can trust in Nsem-Pii say yede bebrem. Honorable Afenyo Macken, the now Ayeka said the current majority leader of the parliament, also the Nsem-Pii, following the declaration by Justice Ejapon, Yankoni Nkotie report on Yeba Nsem-Pii near Asoso.
On Tuesday, the High Court in Accra heard the Mandamus application brought before it by some 4 parliamentary candidates of the NPP, that is for Tema Central, for Ablekuma North, for Okaikwe Central, and also Techiman South. Now, this became necessary because earlier the Electoral Commission had declared the results of these constituencies in favor of the NDC, a move that the NPP would describe as unlawful, because according to them the entire declaration was done based on half results and also due to some intimidation from NDC supporters. Now today on the Channel 1 newsroom we bring you highlights of what happened in court and also reactions from all the parties involved. But first, let's go over to my colleague Hansen Ajman, who sat in court throughout the proceedings.
The NPP, the Electoral Commission, and the NDC came to court on 4 constituencies: Techiman South, Okaikwe Central, Ablekuma North, and Tema Central. The plea of the NPP, who are plaintiffs in this matter, is that the court should order the Electoral Commission to go back and collate results in these constituencies. These constituencies already, the results had been declared for the NDC. The NPP earlier came to the court for a Mandamus application that calls for a collation, or what has become to be termed as recollation. After that, these constituencies were declared in favor of the NPP, except for the Ablekuma North constituency, where the officers were not able to complete the collation exercise. However, the NDC went to court saying that at the first time when the Mandamus application was being heard, their arguments were not listened to, and that their right to natural justice, which is a right to be heard, was not upheld by the court. As a result of that, the Apex Court decided to quash the decision of the High Court. The Apex Court, however, directed the parties to return to the High Court to rehear the Mandamus application. But before that application could be moved, the NDC's lawyer, Godwin Eduje Tameklo, moved a preliminary objection, arguing that the court lacked jurisdiction to hear the matter because of the approach that the NPP used. He argues that if you look at section 16 and section 20 of NDC Law 284, People Representative Law, as amended, any issue as to whether or not a person has been validly elected or as to whether certain results should be cancelled can only be made by way of a petition to the court. Because of that, any other attempt to use any approach, such as a judicial review, as the NPP used in this manner, is a way of circumventing a proper hearing of the matter where evidence will be properly heard. The NPP, however, opposed this and argued that their case does not deal with the issue of declaring or cancelling results. Their case deals with compelling the Electoral Commission, which has a public duty, a duty to conduct elections, to supervise elections, to collate and declare results. They say that from their observations and evidence available to them, The Electoral Commission has not done that. And the Commission itself has admitted to not doing that. As a result, the court should compel the Electoral Commission to go back and do its work. The court, after listening to the parties in the case, including the Electoral Commission itself, whose lawyer also supported the idea that the Mandamus application should be heard in the first place, decided that it will adjourn the case to tomorrow, January 1, 2025 at 10 a.m. and it will give a ruling. At the moment, we'll try and see if we can interact with the New Patriotic Party. Is your side feeling frustrated? Because, the options that we've used the NDC appears to be blocking your chance of making your point.
We have every patience for the law. A court process may be slow, but with surety you will get the results when you know you are on firm grounds. What it is about this, simply put, the Electoral Commission itself has stated with emphasis that there is no such thing as a declaration of results in Ayeka Central, Ablekuma North, and Tema Central, as well as Domiko Abenya. So they have already administratively declared those results as illegal, and the Electoral Commission is doing its work. So this argument that they are declared results is neither here nor there.
I argue that if the Electoral Commission has agreed that there was no proper declaration so-called, this could have been corrected by an administrative fiat. Why didn't you engage them to do
this? Is what they have done. You remember that we were all at Tesano police station. There was an agreement that we should all be at Tesano and do the collation. We were at the Tesano police training school. On Thursday, we agreed to do 4 constituencies. When they realized that we had won all, that was when they started making their noise. Then they threatened the EC, and in the process, EC wrote to the police to provide protection. And it was within that period of delay that we came to court for an order of Mandamus and also for the EC to be protected by the security agencies so that they do their work. That's the application we're on.
Doesn't it make sense to say that determining if an elections have been properly conducted and concluded and determining if somebody has been validly elected are two separate things?
No, they are not the same thing. You see, it all talks about the outcomes. What is the outcome? The outcome is about election results, right? So the simple argument they were making was that Section 16 and 20 of the ROPA Act, that is PNDC Law 284, says that there are 4 grounds you can challenge an election petition, right? And it has made that you are talking about intimidation and the rest. And we are saying that within, you cannot come under Mandamus says that they should perform a public function or public duty